A contract without consideration is void. Ex nudo pacto non oritur actio is a Latin phrase. It means no right of action arises from a contract entered into without consideration. Cause of action cannot be based upon a mere promise or bare agreement. Without a legal consideration, it states that a right of actio does not arise from a naked or nude contract. In other words, out of a promise neither attended with particular solemnity such as belongings to speciality, nor with any consideration, no legal liability can arise. Consideration is an element. Consideration is one of the most essential elements for the formation of a contract. It means something in return. It is the price paid for the contract. Another very important point is that the consideration should be lawful. That consideration should be lawful. It can be either in cash or a kind or otherwise. Consideration has to take place from both the sides. For example, in a contract for the sale of a house, the house is a consideration for one party and the price paid in return is the consideration for the other party. For example, A lends B rupees 100 and B agrees to return it after a month. A month later, B is not in a position to pay back that sum, so B makes an agreement with A promising to pay back after 6 months, and in the meanwhile, A does not sue B for the money. A is not ready to sue B for this money, thus becomes a future consideration for B. A will not sue B in the court of law because why he is not suing him is he remembers that he owes B because B had helped A in the past and had stood by him at a needy time. So A lets go of the money that B is unable to return. This is a past consideration for A, in exchange of which he gives B rupees 100. According to the laws of England, consideration may be present or future, but there is no provision for the past consideration. Past consideration is no consideration in England.